Good evening, ladies and gentlemen. Thank you so much for joining me. This is episode 49 of Untold Evidence. We start July 2023. The Senate Majority Leader of the United States stands on the Senate floor and introduces an amendment to the National Defense Authorization Act. The amendment is pages long. It is modelled, almost line for line, on the JFK Assassination Records Collection Act of 1992. Its purpose: to declassify by force of law every federal government record on unidentified anomalous phenomena. Within 18 months, the most aggressive provisions are gone. Eminent domain stripped. The Independent Records Review Board diluted. The 25-year hard sunset on classification softened. The mechanism for recovering UAP materials from private defence contractors quietly killed. In tonight's episode, what the disclosure bills were supposed to do, what they actually did, and who removed the teeth. So let's lay out what is actually introduced. July 2023. Senator Mike Rounds, Republican of South Dakota, and Senate Majority Leader Chuck Schumer, Democrat of New York, jointly introduced the Unidentified Anomalous Phenomena Disclosure Act. It is attached as an amendment to the FY 2024 National Defense Authorization Act. The bill does several extraordinary things at once. Now, first, it creates, by the Act of Congress, the UAP records collection at the National Archives. Every federal department in possession of UAP-related material is required to identify, catalogue, and submit those records. Second, it imposes a presumption of immediate disclosure. The default is release. The exception is continued classification, and the exception has to be justified. Third, it establishes a 25-year hard limit. After 25 years from the date of a document was created, it must be released unless the sitting president personally certifies that direct harm to national security would result. And fourth, and this is the provision that made the defence sector flinch, it asserts federal eminent domain over any UAP-related material in the possession of private contractors. Translation: if a defence company is holding recovered hardware, the United States government takes it by law. Now, the fourth provision, quite obviously, did not survive. When the FY 2024 NDAA was signed into law in December 2023, the eminent domain clause was stripped. The Records Review Board was reduced in independence. The mandatory release schedule was softened with broader executive override. What remained was a records collection obligation with significantly weaker enforcement teeth. We move to July 2024. Schumer and Rounds reintroduced essentially the same amendment to the FY 2025 NDAA, Senate Amendment 2610, to S 4638. Same structure, same 25-year clock, same eminent domain language restored. On the House side, Tennessee Republican Tim Burchett introduced HR 8424, the UAP Transparency Act, in May 2024. It was simple, a single mandate. Within 270 days, every federal agency must release every UAP-related document on a public website. No boards, no appeal process, disclosure by deadline. In November 2024, Burchett added the UAP Whistleblower Protection Act, designed to protect federal employees and contractors who came forward about UA-related programs from retaliation. In the 119th Congress in 2025, Burchett reintroduced the Transparency Act as HR 1187, substantively unchanged. So what is the evidence that the legislation is responding to? On the 26th of July 2023, the House Oversight Subcommittee on National Security held the first public UAP hearing in over 50 years. It featured sworn testimony from military pilots and a former intelligence officer, 3 witnesses: Ryan Graves, the former US FA-18F pilot; David Fravor, the former Navy commander, lead pilot in the infamous 2004 Tic Tac incident; and David Grusch, former intelligence officer who had served on the UAP task force. Grusch's testimony was the most explosive. He testified under oath and on camera that the United States government has run a multi-decade program to recover and reverse engineer non-human craft. He said he had spoken to direct witnesses. He said he'd been threatened. He said he'd been prevented from telling Congress everything in an open session. Grusch specifically named, in a classified follow-up, individuals he claimed had personal knowledge of recovered material. He stated that some of the material had been moved out of formal government custody and into the inventory of private aerospace contractors, placing it beyond the reach of a standard congressional oversight, beyond the reach of the Freedom of Information Act, and beyond the reach of any executive order short of direct presidential intervention. Now, if that claim is true, it explains the eminent domain provision in the Schumer rounds bill. The provision was not theoretical. It was the precise legal mechanism designed to reach material allegedly held inside private corporation boundaries. Without eminent domain, the rest of the legislation had no enforcement teeth against the very entities it is structured to compel. The Pentagon's All-Domain Anomaly Resolution Office, known as the AARO, which we've spoken about a lot on this channel, issued a public statement before, during, and after the hearing, flatly denying the existence of any such program. The AARO, then Director Sean Kirkpatrick, said his office had found no credible evidence of extraterrestrial origin or off-worldly technology. That was the conflict that the disclosure bill were attempting to resolve. Either Grusch was lying under oath to Congress, a federal crime, or the AARO was. The legislation was designed to force the records into the public view so that the public could see it for themselves. Now, the part of every Untold episode that is a non-negotiable, the counter-narrative. There is a serious case against treating this bill as suppressed civil rights legislation. 1. Sean Kirkpatrick has consistently maintained that the AARO has investigated UAP claims rigorously and found no evidence of non-human craft, no recovery programs, no reverse engineering effort. Now, if that is true, then the legislation is solving a problem that doesn't even exist, or worse, manufacturing a problem. Now, number 2, the eminent domain provision raised legitimate constitutional questions. Mainstream defense policy argues that the federal government cannot, by ordinary legislation, seize private corporate assets without due process and just compensation, and that the provision would not have survived a court challenge regardless. On this reading, what was stripped was not a cover-up, it was an unenforceable language. Number 3. Some skeptical commentators argue the entire disclosure legislation effort is political theatre, a low-cost, low-stakes, bipartisan vote that lets Congress members signal to a UAP curious public without producing real outcomes. Now, we've got to take all 3 seriously. The honest reading is that some of the criticism lands and some of it does not, and at the minute, we don't know which is which. What we do know is this: senior US legislators of both parties believed there was enough on the public record to justify a 64-page declassification statute modelled on the JFK Records Act. The bill's strongest provision was systematically removed before final passing, and the witnesses who appeared before Congress under oath, including a former intelligence officer with a top-secret clearance, were not, as of this recording, prosecuted for perjury. Now, whatever you think is in the records, the pattern is itself worth tracking. If this episode's been useful, please hit the like and subscribe button, and as ever, drop a comment, a question, any sort of response in the comment section, and we'll discuss them as openly as we possibly can. Thank you so much for listening to this episode of Untold Evidence, and we will see you in the next one, episode 50.